Good morning. Good morning, everyone. Happy new week. How's everyone doing? Comment good morning, Deja Vu on Instagram. Comment in the box. Let me know that I'm live. Yes. Sorry, that's one of my staff coming in while I'm live. Anyway, comment in the box and let me know where you're tuning in from. I don't know what flag that is on Instagram. Where are you tuning in from? I don't know what flag is. Put your comments also on Facebook. Let me know where you're tuning in from. If this is your first time joining one of my lives, thank you so much for tuning in. I'll definitely love for you to subscribe to my channel on YouTube. Follow me on Instagram and follow me and like my page on Facebook. When you do that and interact the page, you'll get to see more notifications when I come on live. I try to come on live, give you news as they're happening with the world of immigration. If you have questions, I try to answer them. Wow, good morning from Turkey. What time is it there in Turkey? Oh my goodness. Good morning, Lil Baby on YouTube. Or Lily Baby, and good morning, Smith from Florida. Good morning, guys. Today, it's just really more of a conversation, an opportunity for you to ask questions, or frequently asked questions that you want to know the answers to. I see you guys in my DM all the time. I definitely can't answer all the questions there because it's a lot, but this is your opportunity for me to answer some of your questions. So definitely, type in your question on immigration, and I'll be happy to answer your questions. On my own end, some of the most frequently asked questions I get are, I get this one a lot, where, people are filing, based on marriage or for their children, and them wanting to know whether or not if they don't meet the income, if their spouse doesn't meet the income requirements, can they, what do they do? So typically when you submit a petition on behalf of somebody, usually you have to be able to show a financial affidavit of support that you meet the income requirements. If you don't meet the income requirements, if your spouse doesn't meet the income requirement, or your parent or whoever is sponsoring you, people sometimes say, well, but I meet the income requirement. Is my income enough? The answer usually is that it depends, and it depends on how you're working. So for instance, using a random example, let's say you're married to a US citizen and you came here on an F1 visa and you're doing like OPT, which is occupational training. And while you're doing occupational training, you make the minimum income requirement for a family of two. So for a family of two, the minimum income requirement is $21,775. So, and let's say you make $30,000 and your spouse doesn't. So you are the one that needs the green card. But if you make that, you can definitely include your own income, in addition to whatever it is that your spouse makes to meet it. Murby official says you speak very good. Thank you very much. Good morning. I'm Dean from South Carolina. Chandel says, good morning, beautiful lady of God, for changing lives. Keep up the good work from Mississippi. Thank you. Thank you. Good morning, Emeka on YouTube. As I was saying, so in that case, generally, you can use your own income. But otherwise, if you're working under the table, and doing all of that, that's a bit iffy because you don't really have any way to document your income. So in those cases, you can't use that income. So, and if your spouse doesn't meet the income requirement, one of the things you can do is you can find a joint sponsor. So it is critical when you're looking for a joint sponsor that the joint sponsor is either a US citizen or a legal permanent resident. And you must make sure that the joint sponsor meets the income requirement based on their own taxes. So, for example, if you don't have any children and your wife doesn't have any children, and the income requirement is $21,775, but your joint sponsor could have 3 children. So if your joint sponsor has 3 children and they have a wife, so that's five, a family of 5 plus yourself. So that's a family of 6. So the income requirement is going to jump from 20,000 to whatever the income requirement is for a family of 6. So, it's very different. So whenever you're asking somebody to be a joint sponsor, one of the things that you want to make sure of is how many people do they claim on their taxes? Because once we know how many people they claim on their taxes, then we know how to decide what or whether or not they meet the income requirement. So if you're a conditional green card holder, if your joint sponsor is a conditional green card holder, they cannot do it for you. They have to be legal permanent residents, which means a 10-year green card holder. I don't know why my Instagram keeps disappearing. So somebody asked on Instagram, can a VOW applicant have a child while the petition is still going on? Will it affect the VOW application? So the answer here is that it depends on what's going on with you. So obviously life happens, obviously if you're filing a VOW petition, it means that things are not good in your marriage, and that I am going to say it's safe to assume that you and your spouse have separated, officially. If you've separated officially and, you've moved on with your life and you're doing whatever, that's up to you, but you cannot remarry somebody while your case is pending. So meaning, if let's say you're pregnant, and your spouse is like, all right, let's get married, you cannot do that. If you do that, basically you might as well forget it, because that approval, or you're not getting approved, or you're not getting a green card, one of the two. So please don't remarry until they finish the process of your case. Once they finish the process of your case, then you can do whatever you want to do. All right, let's see. What else do we have here? Somebody's asking, can a green card holder have a firearm? Well, as long as it's legal in your state, and you're following the correct licensing requirements, but still try to make sure you're staying out of trouble, because a green card holder is not the end game. Being a U.S. citizen is the end game. There's so many things that can cause you to lose your green card. An example is this, marijuana is legal, right, in so many states right now, but it is not legal for the purposes of immigration. Okay. And drug is one of the things that USCIS will not forgive. So, or you will have such an insurmountable task getting it forgiven. So if you are in the process, you need to make sure that you're very careful about doing anything illegal, or I should say not doing anything illegal, under the eyes of U.S. immigration, because 1, you could lose your green card, 2, you could get deported. And I always use this famous example of Real Housewives of New Jersey, Joe Giudice, who had been in the United States since he was 2 years old, and when he was in his 40s, he got into some, tax evasion or bankruptcy fraud. He got arrested. He served his time for 4 years, but he was still deported. He has 4 children that are U.S. citizens, including one who's over the age of 21. He has a wife who's a U.S. citizen, but that wasn't enough, to keep him here, because, it was considered a crime of moral turpitude. And that's why when you're a green card holder, even though you get certain benefits of being able to stay here, travel all over the place and work, you always still have to remember that you still haven't reached the prize, and the prize is becoming a U.S. citizen. They are so stringent on the requirements of becoming a U.S. citizen. So you definitely want to stay on the good side of the law. Until that happens. Let's see, what other questions do I have here? Let me just scroll through. You guys are very quiet today. Good morning, Real Zim from New York. Good morning, Samuel. I don't know where you're tuning in from, but good morning. Okay, so let's see, what other frequently asked question do I get asked all the time? Another one I get asked all the time is that if you file for a VOW, do you have to divorce your spouse? Or can you file for divorce? Or can you be divorced and still file for VOW? So let's start first with, if you file for divorce, if you file for VOW, can you divorce your spouse, or do you have to live with your spouse? No, you do not have to live with your abuser. So if you are a VOW applicant, so first of all, for those who don't understand VOW, this is your first time tuning in. VOW means Violence Against Women's Act. So this act, even though in the name it says women, it is for women, men, children, and parents of U.S. citizens, and sometimes green card holders who are dealing with extreme cruelty from either their spouses, their children, or their parents. But specifically, the one that we get asked a lot is about spouses. So when you're married to somebody who's abusive to you and you submit a VOW petition, you're not required to live with that person. As a matter of fact, there's certain state benefits that you get if you get a prima facie determination letter that require you to not live with a person. So, like for instance, in Florida, if let's say you file a vow petition and you get what we call a prima facie determination letter. A prima facie determination letter basically is saying that you meet the bare minimum prerequisites to qualify for VAWA, and so we're going to allow you to get public assistance if you needed it and things like that. If you live with your spouse, you're not going to get that, so you have to move out to be able to get that. Now there are people on the other end that are just truly afraid from moving out of their marital home, because they just want everything to be done because they feel like they don't have anywhere to go or they need their work permit. And if that's you, you can stay in your house. Just be safe while you're in your house, just so there's no requirement one way or the other to move out or to stay back in your house. And then if you're divorced, when you realize that everything that you went through is abuse, you are still eligible to submit a VAWA petition. The only difference is that you have to submit your petition before 2 years post your divorce. So you can't be divorced after 2 years later, you now want to submit. So if you were divorced in like May of 2019 or something like that, or June or July, you no longer qualify. But if you were divorced and it's just been a year ago or like 6 months ago, you're still eligible to submit a VAWA petition. And then this doesn't apply to separation. With separation, if you're not legally divorced, there's no timeline with separation. We've submitted a separation where they've been separated for 10 years, but still legally married. So, it just all depends. And, that's the nuances of, the world of immigration. Susie says, good morning, Aisha. My wife didn't file taxes with me this year, and I have an appointment for a green card soon. What's the outcome of that? So, so not filing taxes with your spouse is not a judgment. It's not a death sentence. Obviously, if you file taxes with your spouse, the better for you. But for a lot of people, sometimes it might be difficult if you just got your green card, your Social Security, and the year before you didn't have the opportunity to work or whatever it is. If you don't have taxes together, it's really critical that you show other things that you have together. Do you guys have a joint bank financial accounts together that's active? People always will say, oh, attorney, we have a joint bank account. And they show me a bank account and there's literally like one transaction in there. USCI doesn't like that because to them, that just means that you created a bank account for your green card purposes, So make sure that if you have a joint bank account, that is an account that is either a bill account that you use for bills or an account that, you use to shop or do so. Just, they want to see activity and they don't want to see activity only from one person because, a lot of times your bank statement will show the last 4 digits of the debit card that's being used. So if it's only one person swiping, they'll say, okay, yeah, this person's name is there, but they're really not doing anything on this account. So, they are very minute and that granular, in studying bank statements. So don't just submit a bank statement if your bank statement is not strong, showing that you're doing something. But, to answer your question, as I mentioned, the non-filing of taxes together is not an automatic denial. Just make sure you guys have other things, to show. Okay. Let's see. Her Excellence says, what do you need one for? I'm not sure what you're asking me about. So Emeka Okoli says, I dated my wife for 5 months before we got married. Will it be a problem when trying to prove it's a bona fide? Listen, love happens to people. People fall in love at first sight. Look at Portia. You guys, if you guys have been following me for a while, you will know that my guilty pleasure is Real Housewives. I watch all the franchises. I enjoy them. I do a lot of brain work during the day. So on the weekends, I just try to clear my head and just entertain myself with Real Housewives. But just to get into Real Housewives for a second, if any of you watch Real Housewives of Atlanta, you can see that Portia got engaged right after a month. She said they're in love. Life is good. She's met the love of her life. So, and so I say that to say there is no requirement of when you should get married or where you should not get married. Just make sure that if you do get married, that you have a legitimate marriage. That's all they care about, that your marriage is legitimate. So, yeah, you might have married a person in a short time, but do you have things to show that, your marriage is real? Do you guys have a lease together? Have you purchased a house together? Did you have a big wedding? I mean, it's hard these days to have a big wedding due to COVID, but did you have something where, quite a few family members attended? Do you guys have joint bank accounts together? Do you have pictures, during your duration of dating and right now? Do you guys have cell phone bills together? So, they look at all those things to decide the bona fides. And remember, when you file, you still have at least, on average right now, we're seeing about 12 months for marriage-based cases. Maybe things will get back to being shorter, but that's what we're seeing due to the pandemic. If you have that, you also have another 12 months timeline to try to get things together that continue to show your marriage's legitimacy. Remember, if you got married today and you submitted your green card application the following month, you're not going to have as much stuff as somebody who's been married for 2 years. So they understand that. They just want to see a continuous showing of the legitimacy of your marriage. Okay. Let's see. Okay, so see here you have somebody, Smith says, me and my wife got married 3 months after we met and our marriage is genuine. Exactly. People fall in love, and sometimes you just know when and you're like, why bother dating for a long time? Let's just get married. So it's not USCIS place to judge you and tell you, no, you need to be dating for 1 year, or you need to be dating for 2 years before you get married. It's just, do you have a genuine marriage, and can you show us that your marriage is legitimate? Somebody says, how long does it take for an I-130 to get approved? That person is asking on Instagram. So the answer is, it really depends on your service center. Right now, there are a few service centers. Some service centers are taking a shorter time. Some are taking a longer time. But on average, we're looking at like at least 8 to 12 months. Things are, well, and let me go back and caveat this out. If you're filing an I-130 with an adjustment of status, which is the actual green card application, your I-130 is going to be approved at the same time that your I-485 green card is approved. So that is definitely like a 12-month timeline. Okay. And again, whenever I give you guys this timeline, remember that there's some people that it's going to be quicker, some people it's going to be longer. I'm just giving you the average because, we've had people that we submitted and 4 months later, they had their green card. That is not the norm, but does it happen? Yes, it does happen. And then there are other people, it's been more than 12 months and we're still waiting. They're still doing some investigation and they're still doing some background search. I find that a lot with certain clients from certain countries. I don't personally think it's fair, but this is what they do. I'll give you an example. Whenever I go to USCIS with clients who are Nigerian, I'm Nigerian myself as well. By the way, for those of you who don't know, whenever I go to interviews with my clients who are Nigerian, I'm not really sure what the bias or what's going on, but those clients never get approved instantly. It usually takes several months for us to get the approval, even though they're there they have a baby, they have a house they bought together, they have all of that. I know that, a lot of this is still coming from the spillover of the previous administration and the ban of, Nigeria amongst other African and Muslim countries. So because of that, they're still doing a level of scrutiny that I don't personally consider fair, as opposed to say, I might have a client from another country, and even I myself, I'm just like, how did they get approved so quickly? I'm happy to help them get approved. But what I'm saying is that, I might have clients from certain other countries and we will be walking out. And before I can even get in my car, I get a notification on my phone, client approved. So that happens as well. So, it really just depends, on what country you're from. Also, if you've been married before, that makes it all the more difficult. Going back again, I just want to focus again real quick on Nigerians. And so let me warn y'all. A lot of times, we as Nigerians, culturally, we don't take paperwork as seriously as maybe, the Western world. So what I mean by that is like, I just told my friend to go submit this divorce decree for me in Nigeria. I told my cousin or my brother, and here it is. And then they present the divorce decree, and then the divorce decree is not valid. It's not valid because it wasn't registered properly or it wasn't authenticated. And so what ends up happening is that they get denied because they say you were technically never free to marry because the divorce is not valid. Right? So you want to make sure that if you're not present and you're asking somebody to help you, that they are doing it properly. They're doing it properly because there's nothing more painful than going through the entire process, knowing you have a legitimate marriage, and then them telling you that they're going to deny you because they've done all this background investigation and your marriage is not proper. Right. And let me segue again into this. I know this is turning into specifically to, because obviously I understand Nigerian clients very well just because, culturally, that's my culture. I also want to talk about marriages, in Nigeria. So in Nigeria, we have two types of marriages. You can have what we call a customary marriage and a court marriage, right? So there's a court registry marriage. A customary marriage, we call it a traditional engagement or a traditional marriage and stuff like that. So that is recognized as a marriage. But if you then do that marriage and you do a court marriage, the court marriage trumps your traditional marriage. So you can't come with a divorce decree saying, here's a divorce decree from a customary court saying that we're divorced. That's not going to work because you already went to court. So now it's a legal marriage based on the court system, on the registry, Lagos registry. So, or whatever registry or whatever state you're in. So you need a proper divorce. So that is why sometimes you see certain people with delays. Now, back to Deja Vu's question. Sorry, I just went off on a tangent. Back to Deja Vu's question. But if you're filing an I-130 alone, you're looking at a timeline of about 8 to 10 months. I would say. I am hoping that with the new extension of the work permits from 1-year work permits to 2-year work permits, that it will make things go quicker. So we'll see. Let's see. So Susan says, I got an appointment for a green card in 6 months without having a social and work permit. How does that work? That happens also sometimes. Sometimes, you remember what I just said earlier, that sometimes some people, their stuff will be quick. And I'm wondering, and I'm curious where your field office is. Where are you located, Susie? Where's your field office? I'm wondering, I have a theory of certain states or certain cities that I think things process quicker. So I'm curious to know where you're from to see if that's where some of my clients that got it quickly are from as well. But if that's the case, what's going to happen is you're going to go for your interview. And if they approve you, there's not going to be any need for your work permit anymore because they're going to issue you a green card. And you will still get your social security. So when you get your green card, if you've still not gotten your green card, your social security, then you can just go to your local social security office and apply for one. Sometimes they might already tell you that we have one in the system. It usually ships from Washington, D.C., which is where the main Social Security Administration office is. If there's none, then they can issue another one. Okay, Susie says she's in Ocala. So you're in Ocala, Florida. Okay, so that doesn't prove my theory because Florida normally actually takes a long time. Florida actually takes 12 months. So consider yourself lucky that your stuff happened so quickly. So good morning, Margaret. Said, I'm still waiting for the phone. I'm not really sure what that means. If you would like to schedule a consultation, if that's what you mean, call us 407-995-6567. Let's see. What else do I have here? So somebody says, my traveling documents were approved through Vowel. Will I have trouble when I want to return? So the answer to this will really depend on your case. So I cannot give you legal advice unless I know your immigration history. I am just going to say, generally, if you don't have any immigration history, meaning you're not in removal proceeding, you were not previously ordered removed or anything like that, then you can travel outside the country. But if you travel outside the country, try not to go for a long time because you don't want to be gone. And then they will schedule you for biometrics or schedule you for an interview or something that you need to be present for. And you're not there, So that's it. Let's see. What else do we have here? Deja said, it's been a year and we still have no response. Okay, if it's been a year, try an e-inquiry. Try an e-service inquiry, like go on their website and do an inquiry online. It's actually easier to do an inquiry online than to call them on the phone because sometimes, they can put you on hold for 40 minutes. or more. And then if you do that and you still don't hear anything, then you can try congressional assistance and ombudsman assistance. Generally, they won't recommend ombudsman assistance if you've not tried other ways to see what's causing your case to take a long time. But yeah, definitely, I would say 1 year is a long time if you've still not gotten, unless you had an RFE. Because if you had an RFE, that usually prolongs your time. An RFE means a request for additional evidence. So did you have one? Because that could be it as well. And Deja says, it's my first wedding. We have a baby together with my wife. I know it's frustrating, but at least you know that you have a bona fide marriage and you would get approved when you go. So just hopefully, you can just continue to use your work permit and travel permit. Somebody says, as a student who got married while on OPT, do I get to keep using my Social Security after the end of my OPT, or do I need to wait for a new work permit? So your Social Security is yours forever. They're not going to change your Social Security. Your Social Security number remains your Social Security number. If you're married to a U.S. citizen and you're filing, you'll get a new work permit. Definitely make sure you submit for a new work permit. But generally in the work permit application, it will ask you, do you want a Social Security number? You already have one, so you don't need one. So you'll get a new work permit does not have the same restrictions. And for those of you wondering what OPT is occupational training. And that's for people who come here on an F1 visa, and then they need to they allow them to either work from 1 to 3 years, depending on their major. But they're very strict on the kinds of job you can have. However, if you are married to a U.S. citizen and your U.S. citizen spouse is petitioning for you, definitely get a work permit that route, because that doesn't have any limit. You can get any job you want with that one. So somebody says, okay, yeah, this is definitely a frequently asked question. Mylan Sarati on Instagram says, can my U.S. citizen spouse file for my mom? So the answer is no, she cannot file for your mom. Only you can file for your mom and your dad. What your spouse can do is that your spouse can, let's say you don't meet the income requirement, you and your spouse can join together and do a financial affidavit of support for your mother. But the child has to be the one filing for your mom. And if you're a green card holder, you can file for your mom. You have to be a U.S. citizen to file for your mother. Okay. All this talking got me thirsty. Okay, so Ogana says, hello, ma'am. How long does Vowel take before one can get a green card approved? It can take anywhere from 2 years to 2.5 years. Because, Vowel petitions take like 2 years. Okay, so once you do your Vowel approval, that gets approved, then they have to schedule for your green card interview. So it could take anywhere from 2 years to 2.5 years. Again, a lot of times I give you guys average. Some people's stuff takes a little bit shorter. Sometimes some people takes a little bit longer, but that's the average where most majority of people fall in. And another way is you can actually Google USCIS processing times, type in the name of your form and type in the name of your field center, office, service center, processing center. That's on the bottom left of your receipt, and it will tell you, what the average time is. Somebody said, I just did an interview on July 22nd, and the officer told my spouse that my case must be reviewed, and I'm just worried, sick. Oh, well, I know it's scary, I know it's scary, but it doesn't mean anything, just as long as you know that you and your spouse have a legitimate marriage, then let them review what they're reviewing. I had an interview last week with a client and their spouse, and I remember no, this, I'm mixing them up. I had one which I thought was a slam dunk case, like we should be getting an approval immediately. And I remember getting a notification the minute the interview was over saying case must be reviewed. And that was like around 12 p.m. And by 5 p.m. that day, the case was approved. Obviously, your case hasn't been approved within the same day, but reviewing your case doesn't necessarily mean that your case will not be approved. Now, I see that you're saying that you're separated. Okay, so then that is a potential problem. And that is something that without having a consultation with you, I can't really be able to give you an advice, because I will need to understand what exactly, if you're separated, how did the two of you end up there? You have a 2-hour interview. Was there a Stokes interview? What is it? So So now that raises a red flag, definitely, even for me, because you're separated and you're attending an interview together. So without a consultation, it's hard to say what your status is. Um, Somebody says, can I still file vow if my ex-husband already did vow? I don't understand. So is your ex-spouse doing vow based on you or what? Or are you, I'm not sure. I don't understand your question. So if you're in an abusive relationship, you can submit a vow petition. So I don't really know what you're saying about your ex-husband, meaning that did he get his own status through vow? Is that what you're saying? But he's abusive to you. Yes, if he's abusive to you and he's a green card holder or a U.S. citizen, you can still file for VAWA if that's what you're asking. Okay, let's see. Determination on YouTube says, is there an interview for VAWA? Good question. So for the actual VAWA application itself, there is no interview. And this is why it is very, very critical that you come in hot, you come in strong with your application, guys. I cannot stress this enough. The bare minimum is just not enough, because you need to be able to present a case that when anybody's reviewing this case, they can step into your position and understand what it feels like a day in your life and what you're dealing with. When they approve you for VAWA, then you could be scheduled for an interview for the green card. Your green card handles inadmissibility. Are you inadmissible or are you admissible to this country? So those are some of the things that it looks at. But for the VAWA application itself, there is no interview. Somebody asked, probably going to be my last question. Somebody asked, does someone with a Primofashi determination letter still have to be scheduled for an interview for a green card? Yeah, you could be, So a Primofashi determination letter is not tied to your green card. It's tied to your VAWA application. A Primofashi determination letter basically says you and your derivative beneficiary meet the minimum requirements to be classified as a VAWA applicant, right? It's not a guarantee of approval, but it's a good sign that your case is moving forth in the right path. So in saying that, it has nothing to do with your green card. Primofashi just leads to a VAWA approval or lack thereof. And then once that is approved, the next step is your green card. Chandria says, good question. Says, is there any age restriction for VAWA parental abuse? Yes. So in order for you to allege as a parent that you've been abused by your child, you have to show that your child is at least 21 years old and a U.S. citizen. If they're under 21, you will not qualify. And keep in mind that with VAWA petitions, even if you entered the country without inspection, or with somebody else's paper, you still have the opportunity to process your case within the United States without having to go back. And if a waiver is required, we will file your waiver within the United States. Stephanie says, what's your number? It's 407-995-6567. It's also scrolling through the ticker right on the bottom of your screen on YouTube and Facebook. Otherwise, it's in my profile. For those of you on Instagram, it's on my profile as well. Somebody says, when are you available for a consultation? Honestly, I don't know. I don't have my calendar in front of me. I do know that my schedule does get booked up quickly, and sometimes it could be a few weeks out. But you can actually log on, go to my website, www.chidelowaylaw.com, and you can see the calendar there, or you can call us, 407-995-6567, and they will tell you when I'm available, and then you can schedule a consultation, okay? So someone says, if my children are citizens and I don't include them on VAWA application, does it affect my application? So let me explain how VAWA works, or how immigration works. There's never a time that is okay not to list your children. Never. Let me repeat that again. Never. You must always include all your children. If you're still married, include your stepchildren. If you adopted children legally, include your adopted children. You must always list your children. And when you list your children, you're going to list what country, where they were born, what they're, and they are going to determine their citizenship. So there's not a separate application for VAWA that you apply for you and your children. It's one form, and all children are listed there. And they specifically ask you, were your children born? If your children are not US citizens, they will be automatically included as derivative beneficiaries, meaning if you get approved for VAWA, they are getting approved for VAWA. So it is never a good idea to not include your children. I know a lot of people make this very silly mistake when they're outside the country and they're filing for diversity lottery, and they think somehow that if they remove their children, they will not get approved. That is not true. Diversity visa is truly a lottery system, and everybody that's included in your family will be approved. It is very painful, and I am so passionate about this because I'm a mother of two children. So it upsets me sometimes when I have to tell a client that basically you either have to give up or be willing to give up your green card and go back home to your children, or there's nothing you can do. You're never going to be able to petition for your children. Do you know how painful that is as a parent? That for a mistake that you made or you thought will help you get to America, you can never petition for your children. I have family members who had made that mistake, and have not seen their children for 20 years. Do you know how painful that is? So please always include your children. It does not stop you from getting approved. It helps your children to come here. So granted, your children are US citizens, but you don't omit them in the application. Just list them because you don't want an issue with misrepresentation, that you lied about something. And then when it's time for you to naturalize, they're going to say you don't have good moral character and you'll never be able to get your citizenship. Sometimes they might even revoke your green card. So please don't do it. Someone says, how long does it take to get a 10-year green card? If I filed for mine 7 months ago, I got the receipt and nothing more. Well, sweet mom on Instagram, the answer is that it really depends. How do you know you're getting a 10-year green card? Have you been married for more than 2 years? So it really depends on how long you've been married at the time your interview is scheduled. But generally, it takes at least 12 months. 7 months is really not a long time. It can take 12 months. So, you just have to be patient. I know it's annoying, but just try to be patient. I hope that you file for your work permit, so at least you have your work permit with you. But it takes time. So somebody asked, what if the children are US citizens already? So I just answered the question. Still write your children. They don't ask you on forms whether or not, if you feel like listing your children or you don't feel like listing your children. The question says, how many children do you have? What are their names? Where were they born? Write it down. Do not omit your children. If you're asking me, should you submit a 485 for your children who are US citizens? Obviously, the answer is no. A 485 is to give people green cards. However, you still have to list. This is how the form goes. The form says, name all your children, child 1, child 2, child 3, child 4. Use the addendum for any more children you have. And then it asks you, are you filing with this child? So obviously you have a US citizen children. So at that point you can say, no, I am not filing for that child. You hit the no cross, but you must still list your children. Let me say that again. Do not omit your children, no matter where their citizenship is. Okay, so sweet mom says, okay, yes, my 2-year green card is up and I'm trying to get my 10-year green card. Oh, girl, then you have a long time to go. You have like 18 months at the very least. 7 months is nothing. I mean, some people are lucky and they will get it approved in 7 months, but that is not the norm. And that is why that's why they extend your green card for 18 months, because it takes that long. Sometimes it takes 24 months. And some people have to go get an info pass and get their passports restamped. So it takes a long time. So you only haven't not heard anything in 7 months is normal, but your receipt is an extension of that 2-year green card. So your receipt should tell you that you have an 18-month green card extension. And if 18 months comes and they still haven't approved you, you can actually schedule what we call an info pass and go get stamped for another 12 months while your case is pending. Remember, even though your 2 year is up, the extension still means that you're still very much a green card holder. You can still continue to work. You can still continue to travel. So as long as your case is pending, you're still very much a green card holder. So good morning, Samuel. Determination says, thanks for answering my question. You're welcome. Fafa Beef says, how long does it take to get an approval for travel documents after filing for it? So normally the timeline is 5 to 8 months. It takes 5 to 8 months, and I say that because that's the average. But right now, I would say in the last month, we've been seeing like a lot of our clients getting approved. So hold on, let me do my math. Around that 5-month mark or 5.5-month mark, and so that is the average we're seeing. But it's a 5 to 8 month window, meaning we can't go back to USCIS after 5 months and say, you've not approved me. You have to wait till the window closes, which is the 8-month window. And when that closes, then that's when, you can reach out to them. But usually when you're scheduled for biometrics for the work permits, it's usually a good indication that in a few months from there, like 2 months or so, that you might get your travel permits or your work permit, depending on what you filed for. Hami Nally says she asked a question. Where is your question? I don't see it. Let me see if I can scroll up. Oh, maybe you put it inside one of these things. Guys, let me try and see how to read these questions. I don't see your question. Okay, I see the question now. What if you file for Vowel but you never receive a Primofashi determination letter? Will my case still be approved? So that's not good. If you didn't get a Primofashi letter, that's not good. Well, the question is, how long ago did you file your petition? And what did you file? Those are all things that usually, if somebody comes to me and says, oh, I didn't get a Primofashi letter, I like to evaluate it just to see if you submitted, claim, because, people think that, okay, my spouse is abusive, I'm going to file for Vowel. So there's still certain things that you have to show to be successful with a Vowel petition other than what your spouse has done to you. And all those things combined together with the cruelty or abuse you face is what qualifies you to get a prima facie and ultimate determination and then an ultimate approval. So we have to know what it is that you submitted to see why you have not received a prima facie letter. Okay. Angela says, good morning. Great information given. Thanks. You're welcome. Ogana says, Nikora Isaac. Yeah, guys, share this live. Tell your friends to come in, even though I'm about to get off now, but still share it because, I find that frequently asked questions are great lives because, all these questions, all of y'all that don't want to pay for a consultation, you can come on here and ask your question. If it's very generic, I will answer it. If it's personal to you, generally, and I need more information, you definitely need to schedule a consultation, but share with other people so that if they have questions, they can ask me. Okay, so Ola says, I filed an I-360 and an I-765 form only, and I received a receipt and a prima facie. Will I get my work permit approved first, or I have to wait for my I-30 to be approved? Please advise. Okay, so if you filed an I-360 and an I-765, you should never have filed the I-765. I am going to go out on a limb and say you probably did this yourself. And this is why you don't submit petitions yourself, because when you submit them yourself, chances of mistakes are very, very frequent. You don't submit an I-765 petition with an I-360 if you're sending a standalone Vowel application. An I-765 is submitted with an underlying petition, which is like a 485 because, maybe you're eligible for adjustment of status as well. Otherwise, you're not going to get a work permit until your Vowel case is approved 2 years from now. So if your case gets approved 2 years from now, you will get a work permit based on your I-360 application, not the I-765 you filed. So you never needed to file the I-765. But more curious is, why didn't you end up doing an adjustment of status? Generally, if you qualify for an adjustment of status, I always recommend doing it simultaneously. because that will allow you to get your work permit much quicker, within 5 to 8 months, as opposed to waiting for 2 years. Okay, guys, I have a meeting, so I have to jump off. This was fun. I will be on live tomorrow, I believe at 11 a.m. So definitely tune in. If I didn't get to any of your questions, tune in tomorrow. I'll try to get your questions and have a fun topic for you guys tomorrow. All right, guys, have a good Tuesday. Bye.